GPS tether, and house arrest, Your Honor.
Okay, one moment, please.
Yes, Your Honor.
Argue. Oh, yes, Mr. Washington.
No, Judge, put your hand down, Mr. Washington. You can put your hand down. Judge, my client's 45 years of age, Judge. This is a case, it's a pretty serious case, Judge. We have Mr. Penny here. My client is charged with shooting at the police, Your Honor. One of the things I want to point out, Your Honor, is that, there was another individual that was shot, his son, on that particular day. Now, there's more to the story, obviously, and there's always a lot more to it than what's in an investigation. So, you have Mr. Washington at his home. You have his son, Your Honor, being shot by individuals. Now, Mr. Washington, in a state of protection, allegedly picks up a gun and starts shooting at individuals that he thinks that are coming for him and his son. And he's defending himself, Judge. And, I look at his statements. Mr. Washington was taken to the hospital and did make some statements saying, motherfucker shooting at me, I'm shooting, defending my family. If I knew it was the police, I'm putting it down. Motherfucker shooting at me, I shoot back. I never shoot the police. Check my record. So it's like Mr. Washington, Judge, is simply trying to protect himself and his family. Now, what the people may try to say is, well, that contradicts a lot of what his son says in terms of when he got shot, timelines, and all that different stuff, Judge. But what I want to point out to the court, timelines and trying to be exact with certain things kind of go out the window when people are shooting guns and it's dark in the hallway and things are happening. So, I understand what the people want to do and putting their case together. I'm glad that there's nobody that actually died here, Judge, and that's a thankful thing. But what I'm saying in this particular case, my client was simply protecting the family, was protecting his son, and that's what it was, Judge. He's not out here shooting at the police, trying to commit a crime. He was simply defending his home at that particular time. I'm asking that his bond be lowered, Judge, to a personal bond with a GPS tether and a house arrest. I also want to point out that he does suffer from he's a cancer patient as well, Judge. And I wanted to point out he needs certain medications. He has strong family support, strong family that's here today that understands, Judge, what really happened. And I don't want this to be spun in a way that makes it seem like my client is a person that goes out trying to shoot at the police. Yes, he has some prior history. 2004, he has some cases that were dismissed. But in this particular case, Your Honor, I want the court to just look at the totality. And I know that Mr. Penny's going to make his argument. I respect Mr. Penny a great deal. But I believe, Judge, in just looking at this and the bigger picture, my client was simply defending himself in this matter.
Mr. Prosecutor.
And Judge, what underlines all this is that, everybody does have a right to defend themselves. However, the defendant in this case is the only person in that building that we could tell that had a shotgun. And when the police get there, after the shooting occurred, they clear the apartment.
Mr. Prosecutor,
is the apartment across the hallway from him has been shot up with a shotgun. There are fired shotgun cartridges in that apartment. And the explanation for that, other than the defendant was somebody else.
Mr. Prosecutor, okay, Madam Clerk, please mute all of the Zoom rooms. There's some portion coming from somewhere. Mr. Prosecutor, the court reporter was not able to hear you, basically. So, got to start over.
Sorry, Judge. I'll start over to make sure we have a clean record on that.
There you go. All right.
So what underlines all this, Your Honor, is after the shooting occurred, the police cleared out Mr. Washington's entire floor. The apartment across the hallway from Mr. Washington had significant shotgun damage inside of it, as well as fired shotgun cartridges. As far as we can tell, Mr. Washington is the only person in that building that had a shotgun, a 12-gauge shotgun. So what that suggests is before the police got there, Mr. Washington was in somebody else's apartment shooting a shotgun. Now, what you can see from body cam during the actual shooting of the police, regardless of whatever happened prior to the police getting there, is Mr. Washington is probably about 30 to 40 feet away from his apartment down the hallway at a T intersection. And as the police are coming up the stairs, moving toward his general direction, he pops out from around a corner and fires without actually looking to see who's there. His head is around the corner, the gun is around the corner, and that's when police return fire. An officer was struck during this exchange. Fortunately, nobody was seriously injured. Now, the police are still looking into whatever happened during the underlying shooting, but what is undeniable is there is evidence that a shotgun was fired in the apartment across the hallway from Mr. Washington. So it's hard to claim self-defense when you have left your apartment, you've walked a significant distance down a hallway to go encounter other people, frankly, what appears to be on a search and destroy mission, and you start shooting your shotgun without even determining who it is you're shooting at. So all of those things, I think, are strong indications that we're going to be successful at trial, Your Honor, and that Mr. Washington poses a risk to the community at large.
Judge, the key words there are as far as we can tell. As far as we can tell. They don't know who was in the apartment before that across there shooting at my client. They don't know everything that happened prior to my client trying to defend himself. His son was laying in the apartment shot. His son had got shot, Judge, by people who ambushed him. So when they say as far as we can tell, they don't know the whole story, Judge. And I think when the whole story comes out in terms of who was there, who was shooting at my client, why my client reacted the way he did in his home, Judge, in his home. You know, he was scared. He was scared, Judge. His son is shot. People had been in there shooting and people had retreated and left by the time the police got there. He didn't know who was coming back. He didn't know what was happening. But the thing is, Judge, there has to be some more investigating here. You're just saying that my client was the only one with a shotgun. As far as we can tell, we don't know. We don't know what happened, Judge. But what I'm saying to the court, my client's not a threat to the police. He's not trying to shoot the police. He's not a flight risk. He is going to come to court. He's going to come to every court day. He has strong family that's here, Judge. He has 6 people down here today in support of him. Because, Judge, this was an unfortunate situation. As Mr. Penny said, an officer was shot. I feel very bad about that, Judge. But my client, again, was defending himself. I don't think he's a threat or a flight risk. I'm asking for personal bond, house arrest, if the court sees fit. But I don't think he should have to sit in the Wayne County Jail and fight this case, Judge. He was just defending his home.
Court haven't heard the arguments of counsel. The court finds that the $100,000 cash bond is an unaffordable bond. In order to have an unaffordable bond, there has to be a showing by clear and convincing evidence that the defendant is either a threat to the community or the complaining witness or a flight risk. There is nothing on the record today that would denote that the defendant is a flight risk. Mr. Reagan is correct. The fact pattern seems to be a dangerous, tragic fact pattern on all sides. There may be some affirmative defenses that the defendant will be able to lodge at a later time, but at this time, the court does find, based on these allegations of the shooting, the type of shooting, the fact that a police officer was struck, the court finds that the bond is an appropriate bond, and the bond will continue.
Thank you very much, Your Honor.
Thank you, Judge. Thank you. Judge, would the court consider 10%? It's $100,000 cash as surety. Would the court consider 10%, Judge?
Not at this time, Mr. Reagan.
Thank you very much, Your Honor.
Thank you, Judge.
Thank you. Mr. Paul,
nice to see you. Nice to see you, Mr. Reagan.
Yes, indeed.
Always a pleasure, Mr. Penny.
Mr. Polk, who do you have? Can you unmute, attorney?
I have Aisha Polk.
Okay. All right.
Calling case number, this is for Aisha Pope, calling case number 24055-21701. People of the state of Michigan versus Aisha Pope. Defendant is being charged with count 1, assault with intent to rob while armed. Count 2, first degree home invasion. Count 3, weapons, firearms, possession by felon. Count 4, assault with a dangerous weapon, felonious assault. Count 5, weapons, felony firearms, second offense. Counts 5 through 8, weapons, felony firearms, second offense notice. Habitual offender, fourth offense notice. Today's the day and time. Boundary determination appearances, please.
Good morning, Judge. Always a privilege. Stevenson for the people, P71917. Good morning to you.
Your Honor, may it please this honorable court, Larry Pope on behalf of Aisha Pope. My P number is 48164. Ms. Pope, would you state your name for the record, please?
We still have.
Please. Wayne County Jail, can you push unmute, Ms. Pope?
Yes, ma'am.
Okay.
Take your name, please.
Aisha Kai Pope.
Argument.
So, Judge, we believe that the bond is unaffordable. My client is a lifelong resident. She has strong community ties. She has retained counsel. She's not a flight risk. She is employed. She works 40 to 60 hours a week for AirC rapid response. She does have some prior criminal history. I'm not going to ignore that, but it's our position that there are a set of circumstances that would allow her to be out on a reasonable bond with tether if the court sees fit to be under house arrest or allow her to be able to go to work. Recently, she lost her father, and she not too long ago, I think it was about a year and a half, she lost a 13-year-old son to drowning. She has some serious medical problems. She suffers from scoliosis, and she is thankfully at this time in remission from colon cancer. But she still has a significant medical history. And so with that, Judge, we're asking the court to consider a more reasonable bond that would allow her the opportunity to fight this case while out. Our suggestion is a $50,000, 10%.
Mr. Prosecutor?
Thanks, Judge. Respectfully, this may be unaffordable, but we find it to be appropriate. And I'm going to put all the previous criminal history aside, and I'm not going to make a flight argument. I think the defendant did the right thing, retaining Mr. Polk. She gave herself the best opportunity to have a fighting chance in this matter. But Judge, this for all intent and purposes, this was premeditated. I mean, we have an individual coming to a house with flowers, pretending these flowers are a gift, giving these flowers to a complainant who opens the door. Complainant passes the flowers aside to allegedly his wife. And this is when the defendant, who's on, surveillance camera, who's on Ring doorbell that captures this whole event, this is where she pulls out a gun and tells the complainant to get down. Like she has more intentions here. And what does the complainant do? I mean, the complainant takes it upon himself. He tries to wrestle the gun away from the defendant. And then what do we have? We have another situation where another individual comes with a gun, pointing it at the complainant after he ended up getting the gun from the defendant. And now, we have this situation where guns are being drawn against each other, the complainant and this new individual. The complainant allegedly ends up pulling the trigger because he's in fear of his life. The gun of the defendant that he wrestled away, that gun doesn't work. He gets inside. Police are called. Judge, thankfully, nobody ended up getting shot here. Nobody ended up getting killed. But, I mean, Judge, we can't do this this is dangerous. I mean, in a community where you don't even know an individual and you're just walking up to doors delivering flowers. I mean, with all due respect to Mr. Polk, we feel as though there's a likelihood of conviction here. We do feel as though she's a danger. I think I was asking for more in arraignment. I got what I got here. We would just be asking Your Honor to continue that.
Before they haven't heard the arguments of counsel, court finds the $100,000 cash bond was an unaffordable bond. This is a surprising fact pattern to see Ms. Pope on the screen and to hear the allegations that are happening. A fake, allegedly a fake delivery announcing "Get Down." I mean this is all a little bit shocking. The court finds that the $100,000 cash bond is an unaffordable bond. Court finds that there's an inherent danger to this type of activity, that Ms. Pope would pose a danger to the community. The court is going to reduce the bond, but the bond is an unaffordable bond is appropriate in this matter. Bond will be reduced to the amount of $100,000, 10%, GPS tether, house arrest, no contact with the complaining witness.
Thank you, Judge.
Wayne County Jail Division 1, can we have Smith? Division 1? All right, 8th floor. What's your name, gentlemen, sir?
Ron Bryson.
Bryson. What's your name again?
Ron Bryson.
LaRon Bryson, calling case number 240552041. People of the state of Michigan versus LaRon Bryson. Defendant is being charged with count 1, armed robbery, habitual offender, 4th offense notice. Also case number 240552051. People of the state of Michigan versus LaRon Bryson. Defendant is being charged with count 1, armed robbery, habitual offender, 4th offense notice. Today's date and time for bond redetermination. Appearances, please.
Judge, always good to see you. Good morning. Steve Vincent for the people, P71917.
Your Honor, may I please report for bringing on behalf of Mr. Bryson, who is appearing via Zoom for bond redetermination.
Okay. Argument.
Judge, my client's 27. He does have some priors. He's on probation, Judge, for retail fraud case. I want to point that out, Judge. He's also a chef at the Detroit breakfast spot company, Your Honor. He works Monday through Friday, 7 a.m. To 3 p.m. He has 2 cases before the court, Judge. One of the cases, I would note, Judge, it looks like it's from a Family Dollar. One of the descriptions, Judge, of my client, or the person, I should say, not my client, but the person that actually committed this crime was a light complexion male. I look at my client, I don't necessarily consider him to be a light complected male, Judge. So, there may be some identifications issues, Judge. When you say light complected male. Again, Judge, these are serious charges. But I do believe, Judge, that based on the nature of the charges, that the court could impose a house arrest tether that could do the same thing as a cash bond in this particular case, Judge. I would ask the court to reduce the bonds. Again, there's gonna be a day in court. My client has he's gonna fight this case. They're gonna have to bring witnesses, line up, doing everything they do. But at this particular point, I'm asking for reduction.
Argument.
Judge, with all due respect, I disagree with Mr. Reagan in terms of identification. We have an individual in 2 different robberies who ended up spelling the same words wrong both times. when he handed a note to the cashier, and there were both family dollars, with all due respect. He was robbing 2 family dollars, but he ended up writing a note with the same misspelled words, the same handwriting, both times to the clerk, putting both clerks in fear of their life, them thinking he was armed, making them believe that he had some type of weapon, and then he robbed both of these establishments, just trying to run a business, just trying to make a buck. And we have an individual who's just trying to, you know, I guess circumvent the right way to do things and just try to take money. Your Honor, I'm not going to focus on the fact that he's already on probation for more than just the retail fraud that Mr. Reagan talked about, but he is on probation for multiple convictions. He had a mask. It was premeditated. He knew what he was doing. He put fear in multiple people in this instance. I believe both of the cash bonds are $50,000 cash, being charged really substantially these armed robberies based on the nature of the offenses, based on what we feel is a high likelihood of conviction with the identification. Your Honor, we're just going to ask you to continue these.
Judge, what's the identification? A light-skinned, light-complected male? I mean, just because a person writes a letter or note the same way, or because a person may have a prior. I mean, I don't, you know, understand what the identification. Because you're arrested for something doesn't mean you did anything. It's an allegation. You're innocent.
Well, I'm sorry, Mr. Reagan. I didn't even get into the fact when they ended up searching the defendant's house, they found the same clothing allegedly that he was wearing at the time that he held up both of these family dollars. So if you really want to get into it, I can get into more identification of this individual.
Judge, and I'm saying that clothing is everybody, a lot of people wear different types of clothing, Judge. And I don't, you know, whether it's gym shoes, whether it's Adidas, whether it's Nike, that doesn't mean because there's clothing that's similar, Judge, that a person committed a crime.
Understood. Court haven't heard the arguments of counsel. Court finds that both, that both cash bonds of $50,000 are unaffordable. The court finds that armed robberies are inherently dangerous situations. The court finds that by clear and convincing standard at this time that Mr. Bryson poses a danger to the community. He's on probation. Seems to have a thing for theft. Seems like things are escalating a little bit more right now with these type charges. The first case, $50,000 cash bond will be reduced to $50,000 personal with a GPS tether and house arrest. The second $50,000 cash bond will be reduced to $50,000, 10%. That's it. Thank you.
Thank you, Judge.